Welcome back to On the Beat. Isaac here again this week, and I have with me Crowell Gillis Cooper, but Will Cooper of the firm. And today, Will, we're going to talk about personal injury damages in the state of Mississippi.
Yep.
All right, so we appreciate you spending some time with us again.
It's good to be here
this morning. All right, first question, different types of damages. What are they, and can different types of damages be awarded in the state of Mississippi?
Right, so the way it's really broken down, Isaac, is compensatory damages and punitive damages. Compensatory damages is what we typically deal with.
Okay.
Compensatory damages are really broken into two types. You've got economic and non-economic. Economic damages are damages that you can basically put a pen to and calculate: your medical bills, your property damage, your lost wages, your loss of earning capacity. Those things that can be calculated because you've been injured in some type of accident.
Okay.
Then there's the non-economic side. The non-economic side, you can't put a pencil to and just calculate. You just have to let a jury decide.
Okay.
And those kind of damages are pain and suffering,
Yeah.
loss of enjoyment of life,
Sure.
mental anguish, loss of consortium. Those kind of things are the non-economic side.
Okay, and then you mentioned punitive damages as
And then,
well.
of course, punitive damages are damages in a case that after the case is tried, the judge decides or the jury decides that it's gross negligence, that it is so beyond, the realm of what is, fair,
Okay.
or where someone is, a drunk driver running over someone.
Right.
So gross negligence that rises to the level of almost of an intentional act, then punitive damages can be awarded.
All right. Well, that's good information to have to get the differences there. How are damages calculated? You kind of already touched on this, but is there? Any other
So if
specifics?
you're in, the jury has to calculate them, and so the bottom line is that it's left in the jury's hands. But what as attorneys have to show the jury is, these type of damages, and then just basically it's in the province of the jury. But most of the time we don't try the cases, we settle them.
Okay.
And so under the law, we kind of look at multiples. For example, if you have $5,000 in meds, I'm representing you as a plaintiff's attorney. I tell you, look, I tell the insurance company involved, we need 5 times his meds to take into account your pain and suffering, the trouble you had to go into, all of those kind of things. So we use multiples to arrive at those damages.
Okay, and then is there a top limit to the amount that you can get?
Well, there is. When Mississippi did tort reform in the 2001 or 2002, they put in a statute that basically says that in a personal injury case, your non-economic damages, those damages that you can't calculate, are limited to $1 million.
Okay.
And so the problem with that is say you have someone who's in a terrible accident, they're a quadriplegic, they're in a wheelchair, the most they can get for that pain and suffering is $1 million now.
Right.
In a medical malpractice case, those non-economic damages are limited to $500,000. And that was a big part of tort reform because the doctors were, the people that were really pushing tort reform.
Sure. Well, that's also interesting facts there too. And one last question quickly here. Can a party still recover even if they are at fault?
They are, and so very quickly, just so an easy way to understand that, say a jury says that the defendant is 60% at fault and you're 40% at fault, and it's a $100,000 reward, you get $60,000 in damage.
So you might be suing for 100, but if they determine 60% at fault, you get 60.
60, that's right. So it's their proportionate share of the fault of the defendant.
Gotcha. All right, well, it's great information, Will. We sure appreciate your time with us this morning. And if you have any additional questions or need any additional information, it's listed there on your screen. We'll be back after this.